Good afternoon, everyone, and welcome to our November webinar where I'm going to be talking about contracts of employment. But before we start talking about contracts, my first love, and hopefully you'll love them as much as I do at the end of this 45-minute webinar. I want to tell you a little bit about Daw Clayton. We are a specialist workplace law firm with offices in London and the City, in the Thames Valley and also in Bristol. And we support clients across the UK, Europe and globally with their employment law issues, litigation, with their training needs, as well as with corporate, commercial and a whole myriad of other services that we offer our clients. If you want to find out more about who we are, and how we help our clients, then please do get in touch. For those of you who don't know me, I'm Emma O'Connor. I'm a partner here in our employment team at Daw Clayton, and I also am head of client training. And I just want to say it's been absolutely fantastic to meet many of you in person at our recent London and Reading events. And I really look forward to getting to meet more of you next year, where we hold some more in-person events and also at our training sessions as well. So big thank you there. And if you want to be a LinkedIn friend with me, where I post information about what's hot and what's not in the world of HR and employment law, then please do scan the QR code below. Our HR to-do list is ever growing, isn't it? And it's going to grow a lot more with the Employment Rights Bill, which I am going to touch upon because it is, major hot topic at the moment. One of the HR to-do lists, and something that I'm talking to many of you about, is obviously your training plans and your training needs. We run leadership and manager training sessions, not just on legal topics, but also HR best practice, as I said, leadership as well, running lots of courses on how to manage disciplinaries, how to manage performance. Again, it's going to be one of those HR hot topics, isn't it, for 2026 and beyond. My Manager Essentials course is a really nice one to engage your managers and give them the confidence to be able to support you in your work, supporting the business. Also doing a lot of work with regards to sexual harassment training for boards, managers, and for wider employee populations. And as we know, those obligations are going to increase, aren't they, with the Employment Rights Bill. So again, please do get in touch, whether that's in-person, virtual or pre-recorded sessions. We are here to help you with flexible training to suit your needs. Right, everyone's favourite, the Employment Rights Bill. So the House of Lords this week on the 17th of November again said no thank you to the government's proposal. The two key changes there that the House of Lords have put forward really concerns obviously unfair dismissal. So as we know, the government wants to make this a day one right. And that's going to have huge implications, as we know. We've got the sort of initial period of employment, which could be 6 months and 9 months, and obviously what effect that's going to have on things like probation periods, etc. The House of Lords said no, we think this should be, as a compromise, we think this should be reduced from 2 years to 6 months. We don't think it should be a day one right. It's going to go back to the House of Commons. So let's see, the government have already said that they're not going to accept it. They've already rejected it twice. It is a manifesto pledge, but who knows? The other thing that the House of Lords are not too keen on is the guaranteed hours. As you know, this is one where if you engage with 0 hours or low hours workers, of which we don't know what the definition is going to be of a low hours worker, or if you use agency staff, then if they work, you have to offer them guaranteed minimum hours based on what they've actually worked over the previous, we think, 12 weeks. House of Lords don't like that absolute offer. They want it to be only made if it is requested. And they also want a definition of seasonal worker. Also some things they're not happy about with regards to trade unions and sort of percentages of votes. So we are none the wiser and no way forward, but, the government can override. Unfair dismissal is a manifesto pledge. time is ticking, of course. We wanted this, or the government wanted this passed back in the summer, then in September, then before conference, and we are, heading near to Christmas recess. So the Parliament recesses on the 18th of December back 5th of Jan. So, time's ticking. If we've got changes that are going to be made immediately within 2 months and then April. So again, watch this space, keep up to date. But what it doesn't mean is that we can keep our eye off what we need to be doing, particularly around the changes. So, it is going to happen. It is going to be passed. It is, obviously we've got the sort of unfair dismissal change happening, whether that's 6 months or day one, but it is a manifesto pledge. It's very unlikely that the Commons and the government will concede on this, but we've got time, but time is ticking. So again, keep in touch, stay up to date with what's going on. And what I am doing is I'm launching a new training course in the new year. Again, it's flexible training to suit your managers, whether you want to come along and join one of our in-person sessions, whether you want to join virtually, or whether you want to run this in-house for your management population. 2-hour course, really high level, but really focusing on managers and their day one, and the day one rights. What is it we need our managers to engage with? Probations, evidence. We need them to engage with changes to family leave entitlements. We need them to engage with absence management as well, don't we, with the SSP changes. So those are the options. We will be sending that out as an invite. So again, please choose, is aimed at managers. And as I said, we can run this in-house, whether you want to run that in person or whether you want to run that virtually. So again, please do let me know. Small classroom style, it is interactive. There will be some case studies, but I really want this to be one where we can encourage our managers to support you in what you are doing in terms of your work. So again, watch out for that, please. Next webinar, December, what have we learned in 2025 will be a look back before we obviously start our 2026 programme. There is a questionnaire that I will be sending out because I am putting together obviously, plans and content for 2026, training courses, as well as webinars and podcasts. So please do get involved with that because this is this is about building that HR community as well. So if there's things you want me to talk about, then, please have your say. Podcasts as well, got one coming out on immigration, but please do check out our previous podcasts. Our last one was on mediation. So again, please do subscribe to find out more. Just a bit of housekeeping. Obviously, I am live, but as ever, this is a high-level overview. I'm not going to be giving you any advice. Yes, you may ask questions, and please, pop those in the chat, some of which I will be able to come back to you on, but others I will come back to you afterwards. But as I said, can't give advice. As with all things employment law, everything is fact specific. I don't know your contracts, so again, I can only really give you kind of high level tips and guides. But again, here to help. And if you want to reach out afterwards, I'll be giving you details of how you can contact me. So what are we going to be discussing? Well, as I said, contracts of employment. And the reason why we're discussing it is because I don't think as employers, I don't think as managers and people leaders, nor as HR teams, that we use our contracts as effectively as we should do. They are a business tool. Yes, there are reasons why we have to have them. We have to have them obviously legally, don't we? Section 1 of the Employment Rights Act tells us so. But there are lots of different ways and ways that we can use our contracts more effectively. So that's really what I'm going to be talking to you about today. Going to be looking at how we spot the contract, looking at some contract curveballs, some things that I've been involved in where there have been some sort of tricky contract issues. Then really looking at what contract terms that you have to have, contract terms that you might want to have. Then I want to look at how we're using them effectively. So that's really talking about how we can use them more as a business tool. So looking at maybe restrictions, what they are, but also thinking about notice periods as well. Remember what this is about. It's just about having lots of different tools in your HR toolbox. Then I want to talk about, reviewing contracts because that's really important as well. Also looking at policies you know, how do policies and how do contracts work? What's all that about? Whether you've got a handbook or a suite of policies, just, you know, discussing that. Everyone's favourite, the ERB is going to have a huge impact, isn't it, on all aspects of how we manage our workforces, how we engage with our workforces, and contracts are going to be a big part of that. So again, we need to discuss. And then, as ever with these, it's giving you some tips and some takeaways of things that you can think about, but also ways in which we can help you as well. So, contracts of employment. Contracts of employment may be in one neat document headed contract or terms and conditions of employment, or you might find that actually as an organisation that your contract, this deal that you have with your employees, the terms upon which that you will act as the employer and they will act as the employee, you may find that it is in a number of documents. Some of you may have it in your offer letter. Some of you may have an offer letter and a contract. Some of you may also have certain collective agreements, so terms that have been agreed with a trade union. I always like to have things in one document. I think it's neater, so we're all clear and all aware of where the contract terms are. What I would say is that if you are using a combination of offer letter and a statement or a contract, that they say the same things. There is nothing worse than having an offer letter that says one thing and a contract which says something else, because then you're in the sort of the realms of, okay, which document trumps which, and it gets very complicated. So let's go back to basics somewhat and really make sure that where we've got two different documents, that they are actually aligned in what they say. Sometimes, however, it doesn't really matter what the contract says, because as we know, employment law rights give certain baseline entitlements, baseline rights to employees, and sometimes obviously they're extended to workers as well. So for example, things around notice periods, we obviously have statutory minimum notice periods, which will override what you may have in your contracts of employment. Always remembering there that those statutory terms are normally like the baseline, and it is very commonplace for employers to enhance those terms in contracts of employment. And really, if the baseline changes and you know is enhanced, there isn't, you know, that kind of overrides everything that we have in our contract. So again, always remember those core basics, those statutory terms. The other way that the contract is formed, obviously, yes, we have express terms that we have written down in our statement of terms or our contract, but also there are implied terms as well that we don't necessarily have to write down, because it's obvious that they apply to the working relationship. And, you know, we're thinking there, aren't we, about sort of health and safety terms there, that they apply. Of course, they apply. We don't necessarily have to write them down. And those terms have been implied, you know, through case law over many years. Also, contract terms, you know, the deal can be formed over time between, you know, in the workplace as well. They can be formed by way of custom and practice. So again, it's not always that we can point to one single document. Sometimes the contract is in potentially lots of different documents. So as HR, we need to be aware of that, but also making sure that we've got that consistency of approach. Often though, we do get contract curveballs, don't we? But the point I will make is that as the employer, there is a much higher bar in terms of you getting it right. There is a higher bar in terms of the expectations placed upon you to make sure that the documents that you are sending out are accurate, they are clear. I saw a document this week which I think had 5 different definitions of how this person was expected to work. You know, freelancer, contractor, 0 hours, employee, agency. I mean, it was, you know, how not to draft a contract. So again, making sure that you've got that consistency of approach, and also making sure that terms are clear. You know, if you don't understand something, then it's very unlikely your employee will as well. So again, I think there's this trend now, particularly with, you know, kind of policies as well, to have that kind of modern language approach. You know, and again, thinking about the terms as well, you know, employer and you, or employer and employee. I'm a big fan of having, standard contract terms, but then those variables, maybe having as a schedule behind. I think it's a nice, neat way of setting out your contracts. But again, you do what works for you and your business. I think the other contract curveball is obviously around, particularly where you've got benefit documents. So sometimes you might say something like, oh, details of our pension scheme or details of our health and safety or our, final salary schemes or whatever they might be, the life insurance schemes, that they might be in a separate document. That's fine, but again, we need to make sure that we've got that consistency and that clarity. So you've got this common thread running through all your documents. So again, we might need to go and check those policy documents and just make sure that what we're reflecting in our contract does actually really reflect what we are offering in practice. Yes, I love to see documents that are signed. It just makes it neater, doesn't it? There are ways of doing that now, obviously with DocuSign and e-signatures, but again, we need to make it signed because again, having to unpick, when was it given, when was it signed, did the employee agree to this? It makes it quite messy. So again, making sure that we've got that consistency. The other issue I see is very much around a lack of kind of awareness and a lack of engagement more generally, not just within HR teams, but within kind of management populations, around just how important this contract is, this deal is that you're offering. It's not something necessarily that we can just, magic up, in a matter of minutes. These things take time to draft, time to really kind of put together. So I do think actually, getting our managers, when I run manager training courses, I say to them all the time, when did you last look at your contract? Do you actually know when you're making offers to people what the actual contract looks like? And many of them will say, no, because we're not, and actually I think managers should be engaged. They should be aware of what the contract is, what the contract means. And when they're asking you to do something or include something within an agreement, I think it's really important that they understand exactly what it is and where the potential legal risks and nuances are of that. I think another big area, again, and I will talk about this in a little bit more detail, is around, using our contracts effectively. So again, do we use them as a business tool? Do we have properly drafted, business protection clauses in there? Have we looked at notice periods? Again, we're looking there at our very senior staff, those that pose the greatest risk if they were to leave. Not for everybody, dilutes their value, a huge, massive no-no. Also, again, are our contracts fit for purpose? Is it just a sort of a series of addendums and we're not really sure what's changed? So again, making sure that we've got that, consistency and clarity. Be warned as well that, the contract, this deal, yeah, we're going to offer you the job and you're going to come and work for us, can actually be formed before the employee steps through the door. So again, there are certain risks there, particularly around if job offers are pulled, and again, take advice on that, because again, there are potential legal obligations around that. The other point I'm going to make is that, when we talk about changing contract terms, it's not easy. Nothing ever is it with employment law? And again, there are huge potential risks there and legal risks and pitfalls that we need to think about when we are thinking about changing terms and conditions of employment. So again, always, always take advice. And again, what I'm talking about here is the deal. The contract is the deal, isn't it? And it's like the contract is the same as any other contract, that you might have in a commercial sense as well. It's just a special kind of contract, isn't it? It's an employment contract. It's a contract of service. It's an employee coming to give you their services. It's not like a contractor agreement where they're just providing a service. The employee, is coming to you to give you that, to work for you. There is this mutuality of obligation, this obligation for you to offer them work, for the employee to do the work, and again, in return to be paid. So it is different. But essentially the elements are the same as any other contract. There is an offer, there is an acceptance, there is this intention to create this legal relationship. The employment relationship is a legal one. And then also there is consideration, the price that's paid for a promise. So again, those are the elements of forming that contract. And as I said, it's not just the day the employee walks through the door. That contract can be formed before somebody has started as well. So we need to be mindful that if we are, if things change, jobs might not be there, that again, that contract is formed. And also you'll find that particularly when I talk to you and one of my first questions is always going to be, what does the contract say? Always go back to the contract. It really is the most fundamental of all documents. So again, we have to make sure that firstly we can find it, it's up to date and actually reflects the true relationship and how the employee is working. But fundamentally, we can't change the contract without the employee's consent. And if we try to unilaterally change the contract, that's actually a breach of contract, which would entitle the employee in certain circumstances to be able to resign and then potentially claim unfair dismissal. That's obviously going to get harder when we think about the Employment Rights Bill, which brings in that prohibition on changing contract terms and firing and rehiring. So it is going to be something which is more under the spotlight as we move forward. It is now, we have a 2024 code looking at fire and rehire. But again, just to sort of flag and to stress, it is not something where you can literally issue a new document, get the employee to sign. It's something, we need to go through a process if we wanted to change fundamental terms. Also, the other kind of red flag there is if you are wanting to change terms and conditions of employment, it might also trigger collective consultation. Remembering there that definition of collective consultation and when those collective consultation obligations kick in is wider than just proposing to dismiss as redundant. So again, we need to have that in the back of our mind as well. And again, remembering ERB changes there in terms of thresholds. So again, it's something that we're going to have, at the fore as well. So yes, we do factor in some flexibility. Of course we do when we draft contracts of employment, things change as we move, but there's always that balance between, okay, how much flexibility do we really have to make changes? But actually, when are we fundamentally changing the terms of which we offered this job to begin with? So, remember, it's the deal. What was the original deal that we offered and to what extent are we changing it? We can't change it, those fundamental terms, without obviously having the consent of the employee to do so, and also thinking about a collective consultation as well. So take note and be warned. So key drafting tips. Well, I think the first one is to always make sure that when you're putting together a contract of employment that you have all the information available to you. So what's the role? What is it, that you are drafting the contract for? And also we're going to need to know what the job description is. Again, job descriptions are going to become much more important, aren't they, moving forward? So job descriptions, also salary information. And again, thinking if somebody's paid less or maybe more than, what others in the team are paid, again, challenge this because again, we need to think about potential equal pay risks there. So again, something looks unusual or out of the ordinary or different, then make sure that you ask. Also think about the risk profile. Who is this individual? What are they going to be doing? Are they coming in at a more senior level? Are they going to have direct access to our clients? Do they have access to our confidential information? Yeah, all of these questions that we need to be asking, to be inquisitive, because again, that might form our whether we give somebody perhaps a slightly longer notice period. It might form whether maybe we need to be thinking about, confidentiality provisions. Maybe we need to think about putting some post-termination clauses in there as well. So again, think about risk profile. Also need to think, do we need some clauses in there, particularly if somebody is a sponsored worker? So again, we need to think about that. Also linked to seniority, we also need to think, do we need to be having somebody on a director service agreement? If somebody's coming in at a director level, and also is somebody coming in at maybe a non-exec, a NED role. So again, think about what you're doing, why you're drafting and who you're drafting for. It's really important. Templates. Templates are great, aren't they? They do save a lot of time, but sometimes speed is not always good. And I have seen, and I've been involved with advising employers in actually quite a few cases where we've used a template, or we've used the previous draft of someone else's contract and we've forgotten to change maybe some personal data. So we've got a bit of a, we've got a data collection issue there. Maybe we've forgotten to change the salary, or maybe we've forgotten to change something else fundamental. So look, they're great, but please always check and also avoid cutting and pasting. There are ways that we can get out where, if mistakes have been made, and I know there's been a couple of questions about that, and I'll come back to you offline. But, it's firstly, we should be getting this right the first time. Yes, we're all under pressure, but this really is such an important document, sets the foundation for our relationship with this individual. We need to be getting it right. So again, avoid cutting and pasting, and also make sure as well that you go back to the offer letter before you draft the contract, and also maybe challenge the manager, what have you agreed here, particularly if something, as I said, is out of the ordinary, so is something missing. Also, is the employee going to need something like a company car? Are they going to have a car allowance? Is there some travel involved? Is the role full or part-time? Again, all of these questions that we need to be asking. And again, please do take your time when drafting contracts of employment. So as we know, the core basic terms and conditions of employment are set out in the Employment Rights Act 1996. And Section 1, so many of you will have you may be calling your document Section 1 terms and conditions. You may have something in your contract that says, this contract incorporates, the terms as set out in Section 1 or complies with Section 1 of the Employment Rights Act 1996. Gosh, that's going to get confusing, isn't it, when we have the Employment Rights Act 2025, but the 1996 Act for now, and again, making sure that we've got that compliance there. And really the Section 1 statement there, and again, this has grown, hasn't it, over time, of the sorts of things that you have to include within that. And we do see sort of, changes periodically to what we need to be including. But really it's the fundamentals, isn't it? It's the core terms and conditions that make the contract of employment work. So it's things around, what's the job title, job description. Maybe you append the job description, or maybe you give a brief summary in there. Place of work, obviously that's changed, hasn't it? What are we doing for people who are fully remote? What are we doing about work from home? Do we encourage people to have, to come into the office? Do we reserve the right in our contracts to say that people do have to come to an office, for things like meetings? It's a good idea to have that flex, isn't it? Again, this is all about tools in your toolbox. And pay and benefits, what's the salary? And again, one of my huge big bugbears is around definitions. Yeah, I really want to see a term in there that defines basic salary. I've seen lots of employers get themselves into a whole heap of knots where they've said, we'll pay your salary. Well, what does that include? Does that include a bonus? Does that include overtime? Does that include commission? So be very, very clear, basic salary. What's the basic salary going to be, and how frequently is somebody paid? Again, if there are things around, commission, bonuses, overtime, again, we need to be clear on what they are. What types of schemes are they? Are they discretionary? Yes, okay, you can have the rules separately, but again, making sure we've got that consistency between our documentation is incredibly important. Also pensions. Again, what do our contracts say about pensions? Auto enrolment, is that after 3 months? And again, you can make that work with your probationary clause as well. So again, we need to be very, very clear, particularly around clauses around those health benefits, health insurances. It's an insurance scheme, so making clear on that. The other big clause to check, and one that I'm always looking at when I do review contracts of employment, is if you have a PHI, a permanent health insurance scheme. Again, really important to check the terms, not just in the contract, but again, making sure you've got that consistency. Hours, of course, how the hours are structured. We need to put in there, don't we? It's sick pay. And again, what we're paying over and above that, if we are. Probationary periods are going to become absolutely key, aren't they? There's going to be lots more scrutiny about how we manage probation periods. There's going to be lots more scrutiny about how long that probation period is going to be. We're not sure. Of course, we're not sure whether it's going to be an initial period of employment of 6 or 9 months. We're not sure if the government is going to accept the 6 months, window. But again, we need to be looking at probationary periods and also how we use them effectively. So I do really recommend that Mastering Probationary course that I've been running. It's a really good one for managers and for HR teams to, again, really focus on the importance of probationary periods. And again, then we've got those statutory requirements, have we? So we need to put in there around things around training. We need to put things around there around holiday. Are there any special rules there around holiday carryover? Do we refer to a policy? Is what we're saying in the policy clear in terms of, is there any contradiction there? Because I see that lots as well. Sick pay as well. What are we saying about sick pay? Is it company based? If it is, are there any limitations with that? If it's discretionary, are there any limitations on that as well? So again, this is all about making sure that where we put things in the contract and we have a policy that they're seamless. And again, when we review contracts, we like to review policies as well, because again, you can't really review one without the other. Other terms, reporting line, again, thinking about those sorts of things. I really like a clause in there about monitoring of social media. Again, many of you will have your separate policies as well, but I think let's put something in the contract. Data protection as well, and particularly if you've got employees who are using your personal data, whether that's your client's personal data or staff personal data, how they should use that. And again, having that separate policy as well. You may have some clauses in there about references, right to work checks, particularly if references in particular have not been checked prior to an employee starting employment. So again, think about the flex in terms of what we can do in our contracts. I also really like a clause around equality. Again, really reaffirming your approach to that, setting out where your policies are, but also reminding employees that, breach those policies, then it is obviously dismissal, which may lead to summary dismissal. Also, as we know, within that Section 1 statement, we must put in the contract who the grievance report and those appeal officers are as well. So again, it's something to really think about when we're writing those contracts of employment. Not having contractual policies, that's something that, is not advisable, but again, just adding in where we need to for Section 1. So contracts of employment. And again, I really do think there is an opportunity for yourselves to really kind of raise the profile of the contract within the organisation. We need to keep them reviewed, we need to keep them updated, and we need to think about how we can use them more effectively. Now, I think when people start work, it's really exciting, and of course it should be. We've spent a lot of time and effort and money in recruiting an employee. But actually, we should also be thinking about how we're going to get out of this relationship if we need to. And I know that sounds kind of a weird approach, but actually, if we do focus on that and we focus on the risk profile, as I've said, I do think that that's something that works really well. So, what am I talking about here? So the big question, what about notice periods? Again, we've got that statutory minimum notice, haven't we? Employers have to give 1 week for every year. So we know that. Also, we need to think about how long that notice period is going to be. For example, maybe for more senior people, they're potentially on a longer notice period. When we think about notice periods, always think about how long potentially it's going to be to recruit somebody into that role. Also think about if we have somebody on a longer notice period, that's having somebody there disengaged for a long period of time. But also think about the other options. So for example, have we got in there garden leave? Again, that needs to be in the contract. Have we got in there the right to pay in lieu, a pylon clause? Again, making sure we've got that really key definition there of basic salary and what you're paid during pylon. And again, thinking about notice as well. Is notice going to be reciprocal? Do you want the employee to give you the same amount of notice as you need to give them? So again, really focusing on notice periods. It is far easier to enforce a notice period when you compare it to enforcing a restrictive covenant. So again, are we using our notice period clauses as effectively as we should do? And I do think we're going to have to start thinking about notice in probation in particular. Do we have those options there with regards to, shorter notice period, garden leave, pile-on, etc. I've had a couple of questions about restrictions, post-termination restrictions. I mean, the baseline for a restriction is the courts don't like them because they are potentially, a restraint of trade. So that's kind of, the top line, the top sort of headline. But businesses do use them. Restrictions are really only necessary for senior employees, senior staff. If you put them into everyone's contracts of employment, you dilute their value. And how can you then seek to argue that they are important and worthy of being enforced? Restrictions must also be reasonable in terms of scope, in terms of geography, in terms of time at the point they are signed. So if you ask somebody who's joining as an office junior to sign them, thinking that we can enforce them in 10 years' time when they're the managing director, no, it's not going to work. They have to be reasonable at the time that they are signed. So really think about your restrictions, get them reviewed. Also think about, when people are promoted, again, is that an opportunity there to revisit your business protection terms? So yes, they are in there. They have to be reasonable. They have to fit the risk profile of the individual that you're seeking to give them to. But again, always take advice with either your current restrictions or also your, if you're thinking about including restrictions as well. They can be a useful deterrent, but they are, expensive to enforce. Other key protections as well that you need to think about is obviously confidentiality. Is your confidentiality clause up to date? Are you using a new Wizzy tech platform now to store client data on? Do we need to kind of do we need to, reference that in our confidentiality clauses? Do we need to include a separate confidentiality agreement in certain circumstances? Intellectual property, if you've got employees who are creating content, who are creating, work for you, again, who owns that? So again, really thinking about intellectual property. And property in general, isn't it? What happens when somebody leaves? How are we going to get the property back? Do we need to know about things like passwords and also contacts as well? So again, lots of things to think about, not just when the employee joins us, but in particular when the employee leaves. So again, have that focus and again, challenge and ask the questions. So action points when it comes to business protection. Again, really think about the level of seniority. Who is it that you are recruiting and what is their risk profiles? Yes, please review contracts on promotion. Again, that's a really good opportunity to really check to make sure that your contract is fit for purpose. Do you have adequate protection if somebody leaves? Again, look at those notice periods. And again, I can't stress it enough. Those restrictions have to be reasonable at the point they are agreed to. Shorter the duration is sometimes better. Again, you can link it with notice. Again, it would be reduced if you put somebody on garden leave. So again, it's about having all these different options available to you, specific and limited, based on risk, role, and also access at the time site. And remember as well, if you're wanting to increase that level of protection, if you're wanting to go over and above the original deal, you need to think about something called consideration. Yeah, what's the price that you're going to pay for getting somebody to sign up to these things? So again, always, please do take advice. When to review, as I've said, contracts need to be reviewed, preferably annually because things do change. Certainly you should be reviewing them at the point of, at promotion times. Also, it's really good to review them around about salary review time as well. If you want to talk about reviewing your contracts, then again, please do get in touch. Now is a really good time as well, particularly with, changes planned. So it's a good time to really think about when was the last time we reviewed our contracts. Policies. Yes, policies are those cultural documents, aren't they? They bring to life the contract. But what's really important is they are non-contractual. They sit completely separately to and outside of the contract of employment. And the reason for that, as I've said, is you want to change the contract, you need to consult, maybe collectively, and you need to get the agreement With a policy, you don't necessarily have to do that, but of course you would communicate it and give people notice of the change. The other reason is because it's easier to change, reflecting, legal changes as well. So outside of the contract, please, they should say that they are non-contractual. Please go and check. Yes, we do refer to our suite of policies in our contracts, but the sanction there is if you breach one of our policies, it is a disciplinary offence, which might include summary dismissal. So again, policies, they're your cultural documents, they explain how things work and how you expect things to be done. But again, they sit outside of the contract. So when were your policies last reviewed? Again, really, we need to be updating those, probably more frequently than we are doing already. And again, send them out. Communication is key with these things. As you know, if you've heard me speak, employees will always say they didn't know. Well, let's change that. Training. We need to be training our managers on our policies. So all of the training that we offer here is training to, your policies as well, to make sure we've got that joined up approach. And then, of course, obviously the impact of the ERB on the policies. So the big change is obviously going to be around fire and rehire. There are going to be those restricted variations that if you wish to change a person's pay, time off work, pensions, etc., then, those restricted variations, then if you do that and if you dismiss an employee because they won't accept that change, it will be automatically unfair. Huge change, a huge restriction on what employers can do. Also, you will not be able to dismiss and re-engage another person who will accept the change. And also you will not be able to include a variation clause. So again, we need to be checking your contracts to make sure that you've got that effective variation clause. If you want to make a change to a person's contract which isn't defined as a restricted variation, it can still be an unfair dismissal. It could still, kick in with the collective consultation obligations. It might not be an automatic unfair dismissal, but it could still be an unfair dismissal. So again, some real, huge changes there with regards to fire and rehire. So please do take notes. Obviously, we're going to have to check, aren't we, our statutory sick pay clauses. I had a question in about, do we need to change the contract for that? I probably would do for new starters. I think for existing staff, you could, write a letter and explain what's changing, but get them to sign that. Again, that's that baseline change, isn't it? So again, that will take effect, because it is automatic. It's a statutory change. Also, we're going to have to be looking, aren't we, at our probation periods, how long those probation periods are. I think we're going to be having to be looking at a shorter potential there in terms of probation period. What's the right to extend, making sure that we don't flip over into any of those territories of 6 or 9 months, depending on where we end up with in terms of the initial period of employment there. So again, there is lots of work to do with regards to the Employment Rights Bill. So my tips and takeaways. Contracts should be in writing. And again, if you've got lots of different documents, please do make sure that you're clear in terms of you've got that consistency of approach, and do ask questions, be inquisitive. Why are we offering this? What are the terms? Because it might impact on things around, pay and benefits for other staff. Again, we have to think obviously around about that, collateral damage as well. If you're going to be changing contracts, we need to take advice, don't we? It's not, it's not a simple operation, particularly if we want to sort of up the ante when it comes to business protection. So again, take advice, please, on that. Come in, there are things that we can be looking at now. Even though we're in this sort of limbo land period, we know the direction of travel. So I think we need to do that. And again, training is always going to be essential in these situations as well. If managers don't know what your policies say and how they should be operating within practice, then really, quite frankly, they're not doing the job that we want them to do. Look at your policies as well, train to them, non-contractual, and they need to be updated. But I'm going to leave with this, is that, your documents are the key to success, aren't they? They are the foundation. They set out the deal upon which you want to employ somebody. Remembering as well that employment relationship is that special relationship. It's a contract of service. You are creating that legal relationship. So again, we need to think about what that looks like and how that operates in practice. So just before we close, Let me just have a quick look at the questions there. A question there around, changing terms and conditions. I mean, leaving aside wholesale changes, but let's just take the example there of where you might increase someone's salary. I think there I would be sending out a letter saying, it's salary review time, we're increasing your salary, please sign to accept the change. So I would be getting employees to do that. So again, I think there's leaving aside a wholesale contract change. If you are changing something like increasing a person's salary, I would get them to sign a letter. I know it sounds a bit strange when you're giving them something better than what they would already be entitled to. Another great one here, how long is custom and practice needed? Again, there is no set time. It's one of those things where, again, what we talk about, don't we, all the time with employment law, it's about facts and it's about circumstances. It could be something that's only been in place, for a short period and something that's been going on for years. It's really around facts, consistency, expectation is a really big one, how we communicate it. But again, unfortunately, when it comes to custom and practice, when it comes to contracts in general, then, we are very much looking at, facts and fact specific. Lots of other questions there. Some of them are very long. And so also some of you have written them as anonymous attendees. If you do that, I'm really sorry, I can't come back to you. So if you're able just to sort of, resubmit with your name, that would be really, really helpful. And then I can come back to you. So questions there, I will come back to those people, but only if you give me your name. So let's talk contract reviews, policy updates, training and HR updates. Please do get in touch and I'll be sharing how you can do that. And remember your 2026 HR to-do list. Also be sending out information about the new Leading Through Change training course, which I think is going to be really, really popular. So I would advise you to get your managers signed up on that as soon as possible. Next webinar, 2025. What have we learned? Gosh, it feels that we've learned an awful lot, doesn't it? So we'll be looking there about, employment and other sort of trends and things that have sort of kicked off in 2025 before obviously then we can look at what trends happen in 2026 as well. So thank you very much for joining me. The link will be available to rewatch this, available for questions, but I really look forward to seeing all of you, please, at the December webinar. It'd be great to see as many of you there as we can do. And then obviously moving through into 2026 and lots planned. Hope to see you all soon. All the best and speak soon. Bye-bye.